Welcome back to Congress Unpacked, bringing you the moments, the clashes, and the truths the headlines leave behind. Let's break down one of the most intense Judiciary Committee moments you'll see this year. Senator John Kennedy grilling Professor Whitney Downs Hermandorfer. If you care about how government power gets checked and who gets to make the rules, this is one hearing you need to understand. Let's start with the headline grabber, the Loper Bright decision. For 40 years, federal agencies got what's called Chevron deference, meaning if a law was ambiguous, courts usually sided with the agency's interpretation. But Loper Bright ended that. Kennedy wanted Hermandorfer to spell it out. Just how much power did agencies really have? She put it plainly. As long as their reading was reasonable, courts let them call the shots. Loper Bright pulled that thumb off the scale and told judges to make up their own minds.
Tell me about the Loper Bright case.
Sure. So Loper Bright is the case that overruled the Chevron Doctrine. And the Chevron Doctrine originally required that if there is an agency statute that governs an agency's conduct, the agency gets deference, meaning a thumb on the scale, when it's interpreting what that statute might mean as it's carrying out its duties. Loper Bright determined that that framework was inconsistent with the Administrative Procedures Act, and instead that moving forward, courts should decide all of those statutory interpretation cases as a de novo matter, meaning the agency doesn't get any sort of special head start.
How much deference did a federal court have to give to an administrative agency under the Chevron Doctrine?
Sure. So the court would originally make a step one determination about whether the statute was ambiguous or not. That's in the eye of the beholder sometimes. But if the court determined that the statute was ambiguous in the relevant sense, meaning it didn't resolve the question the agency was facing, it would defer to the agency's view of the meaning so long as the agency's interpretation was well explained and reasonable.
Next, Kennedy pivoted to the Major Questions Doctrine, linking Loper Bright to West Virginia v. EPA. This doctrine tells courts to be skeptical when agencies try to make huge policy changes without clear permission. Kennedy pressed, now that Chevron's gone, do we even need this doctrine? Hermandorfer argued yes, it's still a guide for when Congress is vague or silent.
What's the relationship, if any, between Loper Bright and West Virginia v. EPA?
So that's a fascinating question. I think, West Virginia versus EPA applied Chevron, but said we're less likely to find ambiguity, and indeed Congress needs to speak clearly if the agency is purporting to resolve a matter of, in the court's terms, political or social significance. And following Loper Bright, of course, there is no deference. And I think some have commented, including Justice Barrett, that the best way to think about West Virginia versus EPA in interpreting statutes is that it informs the context of how we understand what the statutory terms mean in the context of an agency delegation. So the fact that the agency is purporting to carry out its duties might resolve whether or not the particular question is sufficiently clearly delegated by Congress.
That just seems to me like a distinction without a difference. I mean, doesn't Loper Bright wipe out the need for West Virginia v. EPA? Why do we still need a Major Questions Doctrine?
So it's certainly true that West Virginia versus EPA, I think, was partially driven by non-delegation doctrine concerns and concerns about deferring to agencies when doing so threatened our separation of powers. After Chevron has been overruled, of course, that might be relevant in a smaller number of cases, but I do think that the Major Questions Doctrine still has vitality in understanding the best meaning of the statute as Loper Bright now requires.
Then Kennedy dove into the Public Rights Doctrine. Hermandorfer explained the basics. Public rights usually involve government benefits, private rights are classic lawsuits, think property, contracts, or torts. And in Jarksy v. SEC, the Supreme Court said, if it looks like a regular lawsuit, you get a jury, not just an agency tribunal.
What's the Public Rights Doctrine?
So most recently, the Public Rights Doctrine has been applied in the Seventh Amendment context, and the Supreme Court has a decision named Jarksy, where there's a line of precedent saying that if a matter involves public rights, so the conferral of a public benefit, for example, that might be the type of matter that Congress can vest adjudication of in Article I tribunal or in an administrative agency.
What's a public right?
That's a very difficult question to answer in many cases.
That's why I'm asking you.
Yeah, so I think the best way to think about it is to contrast it with private rights. And what the Supreme Court has instructed with respect to private rights is that they're what we would think of as common law type claims. So contracts, property, torts, the stuff of Westminster in the court's terms. And so if you have a matter like that, that's the type of matter that needs to go before a jury to ensure that the Seventh Amendment's jury protections are abided. By contrast, if there's an internal administrative process, Social Security benefits, things like that, that looks more like a public right that wouldn't have existed but for the government granting it.
And what did the Supreme Court hold in, was it Jarkissi?
That's right.
What did the Supreme Court hold?
So the Supreme Court there held that certain matters of the Securities and Exchange Commission actually looked more like common law fraud claims and more like property-based claims that must be tried to a jury in court and cannot be vested in the in-house SEC proceedings to be tried before an administrative tribunal.
Kennedy's final question was blunt. Should a lawyer ever tell a client to ignore a federal court order? Hermandorfer was careful, maybe in extraordinary circumstances, but she refused to give a blanket yes or no.
District court rules in a case. You got plaintiff or defendant, and defendant. You're representing the plaintiff. Your plaintiff is very unhappy. Are there any circumstances under which you would advise the plaintiff to ignore the federal court order?
So, of course, as a judicial nominee, I would be trying to issue proper orders.
I don't want to split hairs here.
No, the normal process is to
I know what the
seek
normal
appellate
process
review.
is. Can you
Right.
think of any circumstances where you would tell the plaintiff, nope, you don't pay attention to this federal judge?
So the problem with answering it that categorically is that there are potentially some very extraordinary situations you could imagine
Like
that
what?
could come before me as a
Like
judge.
what?
So this is a subject of
I'd be
tremendous
careful
scholarship.
there. I'd be real careful.
All right.
If you want more sharp breakdowns like this, hit subscribe and stay tuned as I unpack the next congressional showdown. This is Congress Unpacked. Thanks for watching, and I'll catch you next time.